Good morning, afternoon, evening, whenever it is. Could be midnight, could be daylight savings times, could be standard time. Hello, everyone. Sorry for the delay. I goofed up on the live stream. So instead of making it too complicated, I just kind of set a new time. And here we are, 5 minutes later than I said I was going to be. To all you out there that are here to join us today, hello, everybody. Hello again to Mr. StreamYard, or it might be Ms. StreamYard. I don't know. They've never told me that. Narod, I hope that's pronounced correctly. Gator Boy, Renee, Just Change, Kerr. I'm moving off to the side. Lee, Dustin, Leader Landscape, Hobbs, Robert, Boogie One. Good morning. Hello, everybody. Hope you all are well in our journey following GTII on a near day-to-day basis as we kind of watch the legal proceedings go on. As I told you in my last live stream, I am, to those here that come for the terrible jokes, I've started a new system where I will do 6 jokes, 4 up front and 2 at the end. And the way I am picking what I think are the best 2 jokes for the end, of course. But that's all subjective, and my sense of humor is very peculiar to myself. So everybody else might think it sucks. But anyway, hope you're all great and everybody's doing well. So just to get off to a quick start, why do cows have hooves and not feet? Because they lack toes. How does a penguin build its house? It glues it together. Why don't skeletons fight each other? Because they just don't have the guts. And last but not least, for the opening round, again, I don't believe these are the best of the worst, but the best of the worst are going to be at the end. But last and not least, and please take this to heart, I'm writing a book on reverse psychology. Please don't buy it. All right, so now I'm going to move forward, and we'll touch the last 2 jokes at the very end. So hang in there for the last 2, if you don't want to. Obviously, it's not legal advice. Like, subscribe, shine, clean your computer screen, wash your car, anything like that. Share with all the billions of other people that are interested in this. Please do so. And I thank you for that. So I had put out a something on X or whatever that thing is called about a thought process I had come to about why everything had been so silent. And before I go beyond that, this doesn't talk about any of the other issues. So any of the concerns that I've expressed about allegiance of the receiver, or effectiveness or tactics, doesn't change. But I like to be fair, so I thought about this, and it was in light of a recent comment, and I wanted to put it in perspective. And then since that, of course, there was a couple other things that came up, so I'll deal with those too. So the other things are up is a deposition that's coming up, and then an order on the share on those kind of questionable shares that has been issued by the court. Those all came out recently, in fact, on the 29th, it looks like. So that's yesterday. So I was going to talk about my kind of speculation on why things have been silent, and these 2 additional things came down the pike. So I'll talk about those too. I also know, or at least that's my belief, that John Forster is extremely lost patience in his dealings with the receiver. It's my conclusion, and that he doesn't think he's getting fair treatment from the receiver. And that's my take on it. Could that all change? Of course, but I think that's his take on it as of the current time period in general. I can't speak for him. That's just my impressions, which is not a good thing, obviously. But it's it may in part be caused by some of the stuff that I'm going to talk about today. And so that might change in the future. So, number one, why, I was speculating and everybody's complaining. I know shareholders complain. Why doesn't the receiver communicate with everybody? Why does it seem like there's been like a gap and that people don't know what's going on? And what occurred to me was based upon what we recently find out. When the receiver put out that disclosure about the $20,000 that was released to David Reichman. If you recall, I discussed an email that was later sent to a shareholder, and I think in the email, and I don't know if I confirmed it orally, it was just the email that was sent by the receiver, but they had to get special permission from the SEC to tell everybody that the reason they had approved the 20K was because of a subpoena that was issued to David Reichman. So that led me kind of to think about it a little more. And to get to the subpoena section, there would have to be a formal investigation. Now, we don't know what the investigation is. Is it of Reichman? Is it of all the management? Is it about Alpine? Could be about anything. But I tend to think it impacts GTII because that's what the receiver said. That is one of the reasons why the money was agreed to be released for Reichman was because it would indirectly or directly benefit GTII, or that was kind of the representation. So it got to a formal, because there's a subpoena, that means there's a formal investigation. Before there's a formal investigation, there would likely be an informal investigation. And that could have been going on for a long time. I mean, quite some time. That may, go back years, possibly. We don't know, because those things, and even a formal investigation, are confidential. So, in light of the fact that counsel for the receiver indicated that they sought permission to disclose the issuance of the subpoena, that leads me to believe that they were either, and I'm speculating here, but I bet you I'm not far off here, but I'm speculating. Either the SEC or somebody or some agency said, we're doing an investigation and we don't want to tip off anybody who's subject to the investigation. So you got to be really quiet about all the stuff. That might include about the audit too. Conceivably, that might relate to the audit. So that's one aspect. So perhaps they were told directly to be quiet. And that would be bolstered by the fact, as they indicated, that they had to ask for permission to disclose that the reason they had to get the 20K is because there was a subpoena issued. So they actually had to go to the SEC to get permission. So perhaps there was a directive from the SEC and they're following that and trying to be careful. And if that's the case, and if the receiver was told that, if counsel was told that, then that would make perfect sense why they're silent, because they wouldn't want to rile the SEC or any regulatory body, and that would make, or any other, somebody else doing an investigation. And that would make perfect sense, especially since those investigations are confidential. So that would be one way I was looking at it. The second way I was looking at it is perhaps they have not been told that, but they're just being careful because of concern about that they don't want to be accused of interfering with any type of investigation. And obviously now we know there's some kind of some investigation going on involving a subpoena that was issued to Reichman, but we don't know specifically what the investigation is. But they did. So perhaps they're being super careful and they don't want to step on the toes of anybody. And even if they weren't directed to not talk about this stuff, they're being super careful. And the reason I reference this part is either in the communication I saw in some email with a shareholder or with me, there was some reference that going public or discussing certain things, it was very vague, but the reference was that if he did something, there could be some call that's an obstruction of justice because you're obstructing some kind of investigation. Now, I don't know specifically what that was, and now since the investigation has been disclosed anyway, I don't know what that would be. But the fact that there was a suggestion that it would be obstruction of justice made me think that someone was concerned about their own actions, that they didn't want to be accused of doing anything to interfere with an ongoing investigation that they were aware of. So one or the other, I think, is in play. Either there's an instruction to be confidential and quiet because it's confidential, or they did it on their own to be careful. And if either one of those is the situation, that would be a perfectly reasonable explanation why the receiver and the receivers council have been more silent than we would like. So I try to be fair. So I'm throwing that out as a possibility. Now, again, that doesn't excuse the tactics or, my questions about allegiance or compensation or anything like that. But to be fair, there's been a lot of complaints about silence, and this theory of mine, pure speculation, of course, would explain the silence. And I think there's a real possibility that that is the explanation. It's one or the other, and it reflects what they've been instructed or that they're trying to be careful. So that's that. So that's what I was going to talk about, because that occurred to me when I was thinking about their words that they had to get permission to disclose the SEC subpoena. So that's that part. Okay. Second, so that is my explanation to give them the benefit of the doubt. Second is there was a deposition, I think I referenced it before, Frank Benintendo, and there's somebody else who has a similar name, but it's not the same guy, just so we're clear. And it was originally scheduled in Vegas. A date was chosen. I think an extension was requested by Mr. And I don't know, by the way, because I'm not involved in the scheduling or that process. But I think a postponement was requested. Not unusual, by the way. I think the location was then switched to New York. And then yesterday, I got an amended notice of deposition, and it appears the deposition will take place in Vegas, and it will take place on September 10th. And I will try to attend in some form and to let you know what's going on. This will be the first real deposition that's been taken of a individual. He was on the board. He's part of management. He's also a defendant. It's possible he could take the fifth, which would be interesting if he takes the fifth. I would say that'd be interesting. I don't know if he will. I don't know, what his stance is. But I will watch in some fashion. It's set for September 10th, and I will try to give you some feedback on it, about what basically occurred. And hopefully it goes forward, because, sometimes these depositions, so this will be, I think it's the third date and the third location. And sometimes dates and location, it happens, things get rescheduled. It's not unusual. It's interesting that it went from Vegas to New York back to Vegas. Maybe somebody made a trip, incorporated the trip or something to Vegas. I don't know. But anyway, it'll be interesting to see what he says, since he was involved with the main people that we've all heard about and love, and that the receiver has spent a significant time talking about. So it'll be interesting to see how that testimony turns out. So that's scheduled for September 10th. So that's about 10 days from now. And again, I will try to attend and to give you a report afterwards. So I actually look forward to that, because it's like the first, we've heard about all kinds of stuff, but we haven't heard from the main stars. And here we go. All right. So that's one. So I gave you my speculation about why there's been silence. And then, kind of contrary to that, I talked to you about a deposition that's been set. So that's set by the Receivers Council. They will be deposing. Deposition is to those that don't know, that's an examination under oath where the witness is being questioned, and they'll be asked all kinds of questions related to the dispute. I think they'll be represented by counsel. They will have counsel there. There can be objections stated. Other parties may have an opportunity to ask questions. I don't think I'm allowed to ask questions, to be honest, but I'm sure that most questions will be exhausted, and to the extent they're not, then I'll try to feed somebody questions if that's the case. So and eventually that question and answer is typed up into a booklet form. The witness has a chance to review it, sign it, correct it under penalty of perjury. If he's a defendant, in California at least, I assume it's in Nevada the same way. If he's a defendant, you basically can read, and you're the plaintiff, the side that's suing. If you want to read in his deposition testimony into evidence at trial, if it's evidence you think it's favorable, you can do that without even calling the witness at trial. So especially when it involves a defendant or a party, depositions are extremely important. And depositions also designed to find out what the other side knows, what their position is, to lock them in now, so that later when trial comes and you ask them a question and they say now a different answer, you can point to the fact that on this date I asked you this question, you said this. On this date you said something different. It creates obviously issues of credibility, and that's kind of the purpose. And also purpose is to prepare for what witnesses will say. You also might use the testimony of one witness to prepare for a deposition of another witness. So I wouldn't be surprised, and this is not like telling any lawyer that something they don't know, wouldn't be surprised if they're not using the Benintendo deposition to use in a deposition involving Reichman, something like that. But we don't know at this point in time. But that's what the deposition is set up for. Probably could last the entire day. And that's what's going on in terms of the deposition. So now moving to the second item is, if you recall, originally way back, there was a motion filed or a procedure that was sought by the receiver to deal with those disputed shares. And I think I did a live stream where I kind of made fun of all those disputed shares and all those shareholders. Then I think instead of going directly at them, and instead of like suing Justine Reichman, and instead of taking David Reichman's deposition and whatever, the counsel for the receiver elected to proceed with mediation. Now, as far as I know, because I haven't received any information, the mediation, it appears, because I think we would know otherwise, was unsuccessful. So it did not yield any party agreeing to turn over any shares. Now, that might be not the case. We might learn of that in the future, but as of now, that appears to be the case. Nobody's told us otherwise. And the fact this order kind of suggests otherwise, and I'm not aware of any further mediation, although there could be. So there could be, they could have been unsuccessful to this point in time. They could meet further, but in my mind, at this point in time, there's no evidence that it's been fruitful. I'm sure it's been costly, but not fruitful. And that wouldn't have been the way I would have proceeded. I would have gone on the attack from the start in light of the receiver's reports, and used the receiver's reports as a roadmap to depose these guys, force them either, if the receiver's information was correct, and the receiver's information submitted to the court, so it's deemed, in my mind, I presume the receiver would not submit anything to the court he didn't deem correct. But I certainly think he's established in 4 reports, I don't know who drafted them, but in 4 reports that the Reichman, according to the receiver, engaged all kind of conduct. I would have just gone right to the deposition, let him either take the fifth because he was concerned about potential criminal liability or SEC investigations, which has turned out to be 100% correct, by the way. So originally, in my thinking, and I wasn't aware of any SEC investigation, but my thinking all along, and I've said it, so it's not like this is new, I would have pressed Reichman from day one. I would have skipped the mediation. I would have gone for his deposition. He would have probably dicked around a little bit, but eventually would have gotten him to testify, he would have either testified contrary to what the receiver says, which would have potentially exposed him to perjury, or he would take the fifth because he'd be concerned about, potential criminal liability if he testified contrary to what the receiver has found. And that would have created quite a quandary for him at that point in time, because if he took the fifth in Nevada and in most states, it creates either a presumption or a limitation that makes it really hard for somebody who takes the fifth to win in a civil case. And since the shares are at issue, that would be a good thing, because it would be tough for him. And this would be a perfect example when I talk about the order. It would be tough for him to oppose the order if he had to take the fifth, or if he had taken the fifth. And, as a matter of fact, could he even oppose the order? If he took the fifth and they needed a declaration under penalty of perjury, would he be able to assert a declaration? And that would be with regard to proving up the shares. So again, I strongly urge Receiver's Counsel to immediately set up Reichman's deposition before he opposes any order seeking that his shares be deemed inappropriate. For the obvious reason, if you don't do it, then he can submit a declaration, for example. If you do it, it puts him in a difficult position. So that's my suggestion to the Receiver's Counsel, is depose Reichman ASAP. So what happened yesterday, the third item, again, this happened after I was going to tell you about reason I thought perhaps why the Receiver's Counsel was being silent, is that some time ago, again, the process started where those question shares were frozen, and left to be decided was what happens if there's no agreement as to those shares about how to dispose of them. And the court apparently set out a process. They signed an order, and basically the order sets out a process because basically what the receiver says is that 0.5% of the Gtii shareholders own 52.4% of outstanding common shares. And I think they say also that there was no consideration. Yeah, it does say. As to the issuance of the disputed shares, it was without consideration. So there was nothing paid for it, nothing that was given to deserve the shares to be provided, flowing to GTI from holders of the disputed shares. Moreover, the issuance of the disputed shares materially diluted the holders of GTI common shares that are not disputed shares. And so that's what they're saying. So they're basically saying is there's 0.5% of the shareholders control 52% of the shares. There was no consideration given for the shares. Those shares dilute all the common shares. As a result, and they list all those shareholders again, and the shares, and I think it's about 178 million shares that are outstanding. And they basically are required now to notify all those parties. And once they're notified, they have up to, because there's a couple different periods depending upon how the notice is provided, but they have a maximum of 60 days after they're notified to submit a written challenge to that claim that the shares should be determined. And thereafter, the court will determine the process for adjudicating those, and that the shares shall be remain, there should be no change in the status of the frozen shares. There also is like a document attached that and I think there was discussion about this before, if somebody agrees to return the shares, and perhaps somebody has, but it's not reflected in this, it's not reflected in the 8K, it's not reflected in any report to this point in time, certainly not reflected in this. But there'll be also a document that will permit parties to basically return their shares free of any kind of responsibility. But it doesn't say that that has occurred to date. So the change suggested is, or maybe it's just coincidence, is it seems like the mediation was unsuccessful, and now that they actually have to go forward with the litigation in a more aggressive manner, which I've been clamoring about since day one. So is that that's just the facts. That's just the nature of what this order suggests. And with the deposition of Nintendo coming up, it appears now they're going to try to more fiercely litigate against those parties. And I hope that they do go after Justine based upon what the receiver claims. And I do hope that imminently I see some type of notice reflecting David Reichman's deposition, because I think it's essential that they notice Reichman's deposition before he has a chance to submit any kind of declaration opposing this very thing. So I'm hoping his deposition occurs within the next 30 days. And I think they should notice it, and I will send them out an email to that effect. So let's go over what we did today, and then I'm going to tell the last two jokes. So we talked about maybe perhaps a reason why the receiver and his counsel have been quiet because of, certain regulatory issues. We talked about the new Nintendo deposition and what a deposition is and what you can learn and why you might do it. And we talked about that the court now is proceeding with acting on the disputed shares, and that suggests that the mediation did not result in a immediate victory in our battle. But it also, in light of the Nintendo deposition, it suggests perhaps that the tactics are now changing, and that's where we're going. By the way, I wanted to thank Aaron Foxhunter Ambrose. I hope that's pronounced correctly, with a $9.99 super chat, I guess. And it says, appreciate you taking time and always keeping us updated. Thank you very much. I appreciate you saying, and I appreciate it. So thank you for your response. I much appreciated. Perhaps also, maybe some of this is, and I think it is, with some degree, because we don't want to piss off everybody in the world, if you understand my drift there. But I think our collective efforts do cause action to occur. So I'll just leave it at that. So just keep up the pressure, because you notice we talk about things and then certain things happen. Maybe it's purely coincidence, maybe just the energy flow that we're giving off, but it seems to happen. So keep up the good work, and obviously I will keep you apprised of everything as I go, and I'll keep you apprised of the deposition that's occurring on the 10th. So last and not least, just for the weekend, for the Labor Day weekend, I'll leave you with my last two. What do you do? What do you get? And I think these are my best of the six. So you might have a different feel. I apologize if my selection process is not consistent with your own. What do you get? And I'm sure a lot of you guys have thought about this a lot, and you probably had dreams about this before. What do you get when you cross a vampire and a snowman? Frostbite. How silly you guys are. And last but not least, and on a long weekend, this is really appropriate, I think. And again, probably something that you guys have all tried. I'm sure you've all heard about all these diets and all these drugs that people now can take to do these diets and self-injectables and all that stuff. And so I've started my own. So I'm on a whiskey diet, and I've lost 3 days already. Anyway, have a great holiday weekend. If there's any news that pops up today, Sunday, or Monday, I will certainly pass it on. Otherwise, I want you all to have a really happy and healthy weekend. Take care of yourselves, enjoy yourselves, relax, be safe and sound, and we shall talk soon. So be well and take